Ms. Caproni. Ms. Caproni, you testify that the FBI has done a sufficient job of self-reporting and does not need any statutory remedies to address the abuses uncovered by the IG's reports. Just today, however, the Electronic Frontier Foundation disclosed that documents obtained by the EFF through a Freedom of Information Act request show the misuse of the FBI's National Security Letter Authority, issued at the direction of FBI headquarters, not a field office, went unreported to the Intelligence Oversight Board for almost 2 years. Given that, and the numerous reports of abuse, how is Congress and the public supposed to trust that the Department is capable of self-policing? Don't we need to restore the trust in our intelligence community and checks on our process? And why didn't anyone formally report this matter to the IOB until February of last year?
The incident that you're referring to that was reflected in documents that the EFF recently released was, first off, well before the reforms that we've put into place subsequent to the IG's March 07 report.
Subsequent to what? I'm sorry?
The events occurred prior to the actions that we've taken following the IG's early report. That is, we've put into place a number of controls now that I believe would have first resulted in that NSL not being issued, or second, if it was issued, being reported much more promptly. In terms of why there was such a delay between the time that there was public knowledge of that NSL, and there was public knowledge because it was reported in the press, to March of 07 is unclear to me. There was a direction made to report the incident. It didn't get reported. When we discover it had not been reported, it was directed to be reported, and it then was reported.
Thank you. Now, both you and the Inspector General have stressed the lack of intentional misuse of the NSL authority. It's all due to improper, I shouldn't say improper, insufficient training and so forth. But the Washington Post has reported there was at least one IOB report of willful and intentional misconduct. Does the FBI consider the use of an NSL to seek records beyond the scope of the statute at the specific direction of FBI headquarters not deliberate or intentional?
Chairman Nadler, again, I'm not quite sure why the direction was given to issue an NSL in that case. As I look at what I believe they were seeking from the university, an NSL was not the appropriate way to go. So it's unclear to me whether this was simply a miscommunication. I find it hard to believe that the intent, since we were entitled to the records and we obtained the records pursuant to a grand jury subpoena with the approval of a court, this wasn't an issue of we were seeking records that we weren't entitled to. An NSL was the wrong tool to use, so it's unclear to me why headquarters directed that an NSL be used. Now, again, I think what I'm stressing is there's no evidence of the Bureau using these NSLs to get documents that are simply irrelevant to our investigative mission.
Now, you stated that the majority of abuses were made by third parties, not by the FBI. Now, if a third party gives you too much or improper information, what do you do with it? Can you look at it and issue another NSL to get that very information or more? And wouldn't that be along the line of using evidence that is the fruit of the poisonous tree?
Let me address both issues. First, let me say that we now have in place policies and procedures that require the case agents to review the returns to make sure there is no overproduction. They can't know whether they've got an overproduction or not unless they actually look at what they receive. If they have received information that is in excess of what the NSL has called for, they have to sequester the information. They can then make a decision. If what has happened is the provider has provided us 2 extra weeks of bank records, so those records are still relevant to the investigation, it would be unusual that they wouldn't be relevant, they can issue a new NSL for that information. If it's totally irrelevant, that is, maybe they inadvertently provided us the wrong customer, that information isn't relevant to the investigation, so it can't be used in any way, nor can they issue another NSL for it. That will be sequestered and eventually either returned to the provider or destroyed.
Okay.
More generally, though, your question about fruit of the poisonous tree I'd like to address. Fruit of the poisonous tree is a constitutional doctrine that derives from a constitutional violation. It's important to stress that these are not constitutional violations. These are third-party records held by third parties. There's no violation of the customer's Fourth Amendment rights when we obtain the records that may be in excess of...
Wait a minute. If the third party violated, you could very well have a violation of the customer's Fourth Amendment rights.
With all due respect, sir, that would not be correct under current Supreme Court precedent.
Because it's not the government doing it directly.
No, it's because the records, the customer's privacy interest in the records is not constitutionally protected. Under existing Supreme Court precedent, once they share the information with the third party is free to disclose that information.
And doesn't that argue that in order to protect those privacy records, there's got to be some checks on the third party?
There are checks on the third party. Congress has passed a number of different privacy statutes that provide statutory protection for the document.
And given the fact that everything here is secret, how are those protections guaranteed?
Well,
or enforced?
The issue of the secrecy versus the protection are kind of two separate things.
Well, but they interact with each other.
The provider is still subject to a statutory requirement that they not release the records without appropriate process. That's their obligation. There's still, whether they comply or even if they violate the statute, there's not a constitutional violation. There's a statutory violation.
My time has expired. I now recognize the gentleman.